My name's Michael Dibitetto, live at 2 Tay Road, Hooksett. You probably know I've spent a few years serving on various boards. One thing I learned in that process is you can never be too educated. And as a public official, it's imperative that we know the laws by which we are governed as well as governing. The public meeting law is probably one of the most confusing of them all, and I was pleased to see that we've been enlightened a little bit tonight relative to the issue of what is a public meeting. And certainly consultations with legal parties are not a meeting under the law. I urge anyone that's serving in a public office to get to know these laws. And there are other laws that are important, including the laws that obligate a public official to act in a responsible manner. When one takes that oath of office, you have responsibilities as well as benefits, and it's imperative that you know them. One of the most important of those is not to interfere with another body. It's a violation. We had an ethics clause that was written and was pulled this year, but that really is not important. There are state laws that far supersede any of our local ethics laws. And if you're going to serve on the budget committee or the school board or the police commission or the council, you need to know what laws constrain your actions. I was recently jolted by a letter to the editor in the Hooksett Banner, which read, "I am appalled by the behavior of the Hooksett Police Chief and the Hooksett Police Commission." What's to be appalled about? Are we to be appalled that in the face of a constant and withering, nearly year-long assault, that the chief and the commissioners have demonstrated unbelievable restraint? Over the past months, going on nearly a year, I have observed much appalling behavior, but none of it has been on the part of this Hooksett Police Department. The chief and the commissioners have responded professionally and respectfully to every question. Let's review some of the events that brought us to the place we are at today. The recent irritants appear to originate from two events. The first arises from a decision to reduce the hours of the school resource officer and to seek some cost sharing between the police department and the school department. The second relates to the replacement of the safety center signage. Due to the limits of time, today's comments will be limited to the former. The issue of the SRO commenced as a respectful exchange of communications and proposed solutions between the school superintendent and the police chief. In an apparent effort to bolster the case for maintaining a full-time officer, an elected official, a school board member, Mrs. Willett, wrote a letter to the editor that created the impression that the Hooksett schools were infested with drugs and weapons. As could have been and should have been anticipated, a firestorm ensued. And when the smoke cleared, a number of facts were evident. First, the number of drugs and weapons-related issues was far fewer than we were led to believe. Secondly, the nature of those issues did not support the level of concern that was raised in that letter. One of the highlighted drug issues involved a pot pipe that was found in the teacher's lounge. The much-reported weapons incident involved a knife that was taken from the school and made its way onto a school bus. How did these incidents happen? Has anyone investigated how a pot pipe made its way into the teacher's lounge? Did it fall out of a purse or a pocket of one of the teachers? How about the knife? How did the student sneak a knife out of the Corley school and onto a school bus? These are questions that the public is asking itself. How did a student sneak that knife out? And finally, why were those reports not communicated to the police department in a timely manner? Doesn't the school resource officer have the responsibility to file a daily report just like any other officer on the force would have? A very serious question has been raised on whether those issues were being reported properly and in a timely manner, and whether those confidential incidents may have been shared with a party or parties not authorized to access them. New Hampshire General Laws, Chapter 193, and the New Hampshire Board of Education Directive, ED 317, address reporting requirements for certain incidents. Specifically, written reports of covered incidents must be filled or filed within 48 hours. The statute limits the exchange of these confidential matters to law enforcement officials and school administrators. Has an investigation addressed the question of whether Maura Willett had accessed any of those reports which she cited? Would not that access have been a violation of Chapter 193? It is clear that Officer Defina and Maura Willett have had extensive communications. If this confidential information has been shared with unauthorized parties, have the affected parents been notified of such breach? Furthermore, what is really behind the effort to protect the SRO position? We can now clearly see that the focus of this effort is not just to protect the position of the SRO, but the objective is specifically to save the position for Officer Defina. The proponents have made it clear that no other officer will be acceptable. Why? Clearly, the tenure of Officer Defina has been marked by a near constant conflict with the administration, and he has faced repeated disciplinary actions. We can see that this conflict dates all the way back to the hiring of Agrafiotis as the Hooksett police chief. Whatever promises may have been made by prior chiefs or acting chiefs, it became very clear early on that a number of officers harbored resentments at the hiring of a new chief from outside of the organization. In typical response to the latest disciplinary action, an anonymous list of grievances against the chief has appeared. Reappeared would be a more accurate word, as this list is essentially a warmed-over recitation of the same list that was raised 4 years ago. Those charges were made and adjudicated and found to be without merit. Most importantly, that incident left the Commission realizing that its ill-advised attempt to respond to the complaint left it severely compromised, and it left the chief unfairly maligned. I would trust that no amount of badgering will compel this board to repeat that mistake. It is important to know that despite the many allegations made against the chief by this officer, and considering the long history of the Teamsters' willingness to grieve such complaints, that no record exists of any complaint having been brought before either the Superior Court of the State of New Hampshire or the New Hampshire Public Employees Labor Board. No complaints exist that warrant those to venues. Instead, the actions that have been taken are in direct violation of the union contract, which specifically prohibits any officer from taking actions which are outside of the agreed-upon grievance process. It is abundantly clear that this officer has conspired with public officials to interfere with the Hooksett Police Department's operations. The Budget Committee's actions to punish this chief and the department through the budget process are a clear violation of state laws regulating the behavior of public officials. Has this commission enforced the contractual obligations of the Teamsters union contract to restrain Officer DeFina from taking his grievance outside the process? The citizens of Hooksett are a party of interest to this contract, and we have a right to be assured that its provisions are enforced. One final note. The coordinated attack letters in the banner never fail to assert that they represent the opinions and feelings of the citizens of Hooksett. Let me assure you that they do not respect a silent majority that finds them unfair, distasteful, and abhorrent. Many have communicated their interest in correcting these problems with the public officials who are responsible and are willing to take the necessary legal steps to do so. Thank you for your time. Appreciate it.
Thanks, Mike.